Restrictive covenants, along with zoning ordinances, are the primary means of controlling the development and use of real property. Local governments generally control zoning restrictions, while property owners generally control restrictive covenants. What if a single property owner in a larger tract of land governed by a covenant refuses to change the covenant? Do the remaining property owners in the tract have any remedy to force the sole holdout to release the covenant? The Supreme Court of New York, Westchester County, addressed this issue in Rick v. West. In 1946, Chester Rick purchased a 62-acre parcel of rural land in Westchester County, New York. The land was then free of any restrictions from either covenants or a zoning ordinance. The next year, Rick filed a covenant with the Westchester County Clerk's office restricting the parcel to exclusive residential use with single-family dwellings. Rick intended to develop a residential subdivision. The covenant also stated that, quote, special unforeseen conditions may require exceptions, unquote. In 1956, Rick filed a slightly revised restrictive covenant for the parcel, which still limited the development to single-family homes. The same year, he sold Catherine West a lot, and she built a house on that lot the following year. West was influenced to purchase the lot because she desired to live in an area with deed restrictions that limited construction to single-family homes. In the following years, Rick only sold a few more lots in the parcel. The vast majority of it remained undeveloped. Rick successfully applied to rezone the bulk of the remaining parcel to allow for non-residential use. However, he didn't inform the Planning Commission of the restrictive covenant affecting the larger parcel. In 1959, Rick conveyed his interest in the remainder of the parcel to a family trust. In 1961, the trust contracted to sell 15 acres from the parcel to a hospital, conditioned on the release of the restrictive covenant by all affected landowners. West refused to release the covenant. The trustees sued West, seeking a declaratory judgment that the restrictive covenant was no longer valid. They noted the clause in the covenant stating that, quote, special unforeseen conditions may require exceptions, unquote. The trustees claimed that the proposed sale of the 15-acre portion of the parcel to the hospital was such a special unforeseen condition.